If you were born before 1965, there is a completely legal, government-approved process operating right now that is designed to drain your bank accounts, force the sale of your home, and wipe out your entire life savings the exact moment you or your spouse needs long-term care. And the people who come for your money will do it legally, out in the open, without breaking a single law. But here is the secret that nobody tells middle-class families. Wealthy people do not lose their homes to nursing homes. They just don't. They use the exact same legal system to make their houses and their assets completely invisible to the government. And they do it by signing 3 very specific pieces of paper long before they ever get sick. One of these papers is actually something you probably think you already signed. Maybe you have it sitting in a file cabinet at your house right now. But if that document is missing one specific paragraph, just a few quiet legal sentences, it is completely useless when the nursing home comes knocking. My name is David Taylor from Senior Money Brief. For years, I have studied the exact documents, the hidden rules, and the legal loopholes the system uses to quietly separate older Americans from the money they worked their entire lives to save. Today, I am going to walk you through all 3 of these papers in plain English. No legal jargon, no confusing theories, just exactly what you need to know to build a permanent wall around your money. Let us start with the single most expensive lie older Americans believe. Ask almost anyone over 65 who pays for a nursing home if you have a stroke or develop severe dementia. They will confidently tell you, Medicare. That is flatly, completely wrong. Medicare is health insurance. It pays for your hospital stays. It pays for your doctor visits. It pays for your prescriptions. It does not pay for long-term custodial care in a nursing home. The only government program that pays for long-term nursing home care is Medicaid. And Medicaid is a poverty program. It was built with one brutal, unbending rule. Before the government pays a single dollar for your care, you have to go broke first. They call it the Medicaid spend-down, and it is exactly as devastating as it sounds. Imagine you need nursing home care tomorrow. The facility costs $9,000 or maybe $11,000 every single month. The state looks at your finances and says, "We see you have a savings account. We see you have a retirement fund. Start writing checks. You are legally required to drain your own life savings, cash out your IRAs, and empty your checking accounts to pay that monthly bill out of your own pocket. You have to keep paying until you are legally impoverished. In most states, a single person is only allowed to keep about $2,000 to their name. $2,000. After 40 years of clocking in, paying your taxes, and doing everything exactly right. And what happens to the house? You might be sitting at your kitchen table thinking, well, they can't touch my house. My house is protected. That is the second dangerous myth. If you go into a nursing home and Medicaid eventually steps in to pay for your care, the state keeps a running tab of every single dollar they spend on you. And when you pass away, the state triggers a legal process called Medicaid estate recovery. They place a legal claim on your house. They force your children to sell the home you raised them in, and the state takes the proceeds of that sale to pay themselves back. You worked for decades to leave something behind for your kids, and the state legally takes it in a matter of months. That is the trap. The system severely punishes the people who saved. But remember what I said at the very beginning. The wealthy do not let this happen. They don't go broke, and they don't lose their real estate. They use a specific legal vault to hide their house from the government. And that brings us to the very first piece of paper you need to sign. Paper number 1 is what I call the asset vault. But in the legal world, it has a very specific name. And before I tell you what it is, I need to shatter a massive illusion that gives millions of seniors a fake sense of security. Right now, thousands of you watching this are thinking, David, I don't need to worry. I went to a lawyer. I set up a trust. My house is perfectly safe. Let me be as clear as I possibly can. If you set up a standard revocable living trust, the kind 95% of people have, the kind that avoids probate, it does absolutely nothing to protect your home from a nursing home. 0. Here is the golden rule of Medicaid. If you can get to your assets, Medicaid can get to your assets. A revocable trust means you can change your mind. You can take the house back out whenever you feel like it. Because you still have total control, the government looks right through that piece of paper. They consider that house to be yours, and they will force you to spend it down. To actually build a wall around your home, you must use a completely different legal tool. Paper number 1 is an irrevocable Medicaid asset protection trust. Notice the first word, irrevocable. Think of this trust like a heavy steel vault. When you put your house inside this vault and lock the door, you are legally separating yourself from the ownership of that asset. You are telling the government, I do not own this anymore. And because you do not legally own it, Medicaid cannot count it when they look at your finances. When they do their brutal spend-down math, that house is completely invisible to them. When you pass away, Medicaid estate recovery cannot touch it because your name was not on the deed, the vault's name was. Now, I know what you are thinking. David, I don't want to give away my house. Where am I supposed to live? This is the genius of this specific trust. When it is drafted correctly by a specialist, you retain the absolute legal right to live in that house for the rest of your life. You still pay the property taxes. You still get your senior property tax exemptions. Nobody can kick you out. Not the state, and not your kids. You maintain your life exactly as it is today. But on paper, the house is shielded. If you ever need a nursing home, the state cannot force a sale. It passes safely to your children, exactly the way you always intended. This is the exact strategy the wealthy use to preserve generational wealth. They do not leave their biggest asset sitting out in the open. They lock it in the vault. But protecting the house is only step one. Because what about your cash? What happens when you start getting older, and instead of a nursing home, you want to stay in your protected house, and you want to pay your daughter or your son to take care of you? If you do that the wrong way, you will trigger a devastating Medicaid penalty that can ruin your family financially. Unless, of course, you sign paper number 2. Most older Americans do not want to end up in a facility. They want to stay right in their own home for as long as humanly possible. And to make that happen, they usually rely on family. A daughter comes over to cook meals and manage medications. A son takes time off work to drive you to doctors and handle the maintenance. Because you are a good parent, and because you want to help them out for sacrificing their time, you write them a check. Maybe you give your daughter $1,000 a month to cover the shifts she is missing at her job, and the exact 3 phone calls to make this week. It seems completely fair. But if you do this the way most people do it, just handing over a check or transferring cash, you are walking straight into a devastating Medicaid trap. Here is the problem. When the day finally comes that you do need a nursing home, Medicaid is going to look at your bank statements. They will see those $1,000 checks going to your daughter. And because there is no official paperwork proving she was working for you, Medicaid will legally classify every single one of those checks as a gift. Medicaid hates gifts. They view gifting as you intentionally hiding your money so the government has to pay your bill. So, what do? They hit you with a massive penalty. They will look at you and say, you gave away $30,000 to your kids over the last few years? Fine. We are not paying for your nursing home care for the next several months. Figure it out. You could be lying in a facility bed, completely out of money, and the government will legally refuse to pay your bill because you tried to help your own children. This is exactly why you need paper number 2, the personal care agreement. Some lawyers call it a caregiver protection agreement. This is a formal, legally binding employment contract between you and your child. You have to sign it before the care starts. It spells out exactly what your child is doing for you: grocery shopping, bathing, cooking, driving, and it sets a reasonable hourly rate for those services. When you sign this paper, you change the entire legal reality of the situation. You are no longer gifting money to your kids. You are officially hiring them as an independent caregiver. Now, when Medicaid sees those checks, you hand them the personal care agreement. You prove that you were paying fair market value for a necessary service. The penalty vanishes. Medicaid cannot punish you. You successfully transferred thousands of dollars of your own savings directly to your children, completely legally, and the nursing home cannot touch a single dime of it. So you have the vault to protect your house. You have the care agreement to protect your cash. But what happens if you wake up tomorrow morning, a severe stroke hits, and you cannot physically hold a pen to sign anything? Let us stop for a second. Because if you are married, the trap I am about to show you is the single most terrifying part of this entire system. It is the exact reason families are completely destroyed overnight, and it is why you cannot afford to tune out right now. Most married couples assume that if one of them gets sick and goes into a nursing home, the healthy spouse, the one still living at home, gets to keep their half of the money. That is a very logical, very fair assumption. And under Medicaid law, it is completely wrong. When you are married, the government does not care whose name is on the bank account. They do not care if you kept your money in separate accounts for 40 years. They do not care if it is a joint checking account or an individual IRA. Under the rules, all of it is thrown into one giant pot. If your husband has a severe medical emergency and needs a nursing facility, Medicaid is going to look at everything the two of you have saved together, and they will force the healthy spouse to spend almost all of it down before they pay a single dime for the sick spouse's care. They call the healthy spouse the community spouse, and the rules for the community spouse are absolutely brutal. In many states, the healthy spouse is legally allowed to keep only a fraction of their combined life savings. It is called the Community Spouse Resource Allowance. Depending on where you live and what you have saved, the state might force you to write checks for hundreds of thousands of dollars to the nursing home until you hit their rock-bottom limit. Imagine being 75 years old, completely healthy, and watching your entire retirement fund get drained at a rate of $10,000 a month. You are left with barely enough to pay your utility bills, cover the property taxes, and buy your own groceries. The system literally forces the healthy spouse into poverty just to keep the sick spouse alive. It is the healthy spouse's ultimate nightmare. The system is entirely rigged against the person left behind. But you can stop this financial bleed. You can step in and save the healthy spouse's money, transferring it to safety, or shielding it completely. But to do that legally, you must possess the absolute legal authority to move those assets. And that brings us to the most misunderstood piece of paper in America. Here is the exact document that stops the bleed. Paper number 3 is the one that shocks people the most. Why? Because if I asked you right now, you would probably tell me you already have this handled. You went to a lawyer a few years ago, or you printed a form off the internet, and you signed a power of attorney. You put it in a safe or a desk drawer, and you assume you are completely protected. But if you do not pull that document out today and check for one specific paragraph, you could lose everything. A standard power of attorney is designed to let your spouse or your kids pay your utility bills, cash a check, or talk to your health insurance company if you are in the hospital. It is a basic, everyday convenience document. But a standard power of attorney is completely, 100% useless when it comes to saving your life savings from a nursing home. Here is exactly how this nightmare unfolds. Let's say your husband suffers a severe stroke. He cannot speak, and he certainly cannot sign legal documents. The nursing home bills start piling up at $10,000 a month, and you realize you need to move the money out of his name to protect your own financial survival. You take your standard power of attorney, you walk into your local bank, and you tell the manager, "I need to transfer these funds into a protected trust so we don't lose everything to Medicaid." The bank manager looks at your document, shakes their head, and says, "I am sorry. We cannot let you do that." Why? Because your standard document is missing the most critical legal phrasing in the entire elder law system. It is missing the broad gifting powers. If your power of attorney does not explicitly and specifically state that your agent has the right to gift assets and conduct Medicaid planning, you cannot move the house into the vault. You cannot transfer the cash. You cannot shield the investments. The bank will not let you, and the state will not let you. Because you do not have that one specific paragraph, you are trapped. The only way to get the legal authority to move that money is to drag your own spouse into a courtroom, stand in front of a judge, and spend thousands of dollars to fight for a legal guardianship. By the time that painfully slow court process is over, the nursing home has already drained the bank accounts. You do not just need a regular power of attorney. You need an enhanced durable power of attorney, drafted by a specialist, that specifically includes unlimited gifting powers for Medicaid asset protection. When you have that exact piece of paper, your spouse or your children can instantly move your money to safety the moment a medical crisis hits, without ever asking a judge for permission. But here is the final, brutal catch. You can have the asset vault, the care agreement, and the enhanced power of attorney perfectly signed and perfectly legal. But if you do not understand the invisible ticking clock that controls all of them, the government will still take your money anyway. You now know the 3 pieces of paper that build an invisible wall around your money. But there is a massive, invisible trap hiding right behind them. And this is the one that catches the people who try to do everything right, simply because they waited just a little too long. The federal government has a strict rule. It is called the 5-year look-back period. And it is the most unforgiving, brutal deadline in all of retirement planning. When you apply for Medicaid to pay for a nursing home, the state does not just look at what is in your bank account today. They legally demand to look back at every single financial move you made for the last 60 months. 5 full years of your bank statements, your tax returns, and your property records. They are looking for one specific thing: Did you move any money or transfer any property to avoid paying the nursing home? If you put your house into the asset vault, or if you transferred savings to your kids, and you apply for Medicaid 4 years and 11 months later, the government will catch it and they will severely penalize you. They will tally up everything you moved in those 60 months and legally refuse to pay for your care until you somehow cover that exact amount out of your own pocket. But if you transferred that house to the Irrevocable Trust 5 years and 1 day ago, you are completely clear. The government cannot touch the house. They cannot penalize you for it. It is entirely safe, and the nursing home bill gets paid by the state. This means you cannot wait until the doctor gives you a bad diagnosis to sign these papers. You cannot wait until you feel a little unsteady on your feet. If you wait until the crisis arrives, the 5-year look-back rule will trap you, and the papers will not save you in time. You must sign them while you are healthy, while you are sitting at the kitchen table, perfectly fine, living your normal life. The clock is ticking right now, whether you realize it or not. The rules are brutal, but they are predictable. And when you know the rules, you can protect yourself. Here is your exact checklist. First, you need the Irrevocable Medicaid Asset Protection Trust, the Asset Vault, to make your home legally invisible to the state. Second, if you plan to pay your children for care down the road, you need a signed personal care agreement before any money changes hands. Third, pull out your power of attorney today. If it does not explicitly include broad gifting powers for Medicaid planning, throw it out and get it redone immediately. But do not go to the guy who handled your traffic ticket or closed your real estate deal. Do not download these forms off a cheap website. The stakes are too high, and a single missed sentence costs you your house. They know the exact words to put on these 3 papers so they actually work when the crisis hits. Do not let the system take what you worked 40 years to build. Sign the papers while you are healthy, start the 5-year clock, and keep your money and your family where it belongs. I am David Taylor. If this video helped you, send it to one person you know who is over 60, because I promise you, nobody else is telling them this. Subscribe to Senior Money Brief, and I will see you next time.